A lot of people have been asking me for updates on the Bootstomp case, also called the Bootstomp dog crawl case. This is a excessive force case, federal Section 1983 lawsuit that was pending in federal court in West Virginia. It happened actually in western Greenbrier County, near where I live. But the big news is today that that case is now officially settled. So what that means is that the defendants had agreed to a financial settlement with my client. And, remember, these are civil cases, and the only remedy available to us, given to us by Congress, is to get money in exchange or as a consequence of civil rights violations. We can't get police officers disciplined or terminated. We can't get them prosecuted. Those are up to the employers and state and federal prosecutors, respectively. The remedy available to us is to get money. And in this particular case, a lot of it was caught on video. I think it was a pretty strong case. You had two basic types of civil rights violations alleged here. You had excessive force, which would be the boot stomp, and then you have Fourth Amendment search and seizure violations of this is a man's house. There was no search warrant. There was no arrest warrant. They violated the threshold of his home. So while excessive force and search and seizure both fall under the Fourth Amendment, there are two different types of violations. In any event, we ended up not having to go to trial in this case. And I think in my opinion anyways, a lot of the reason for that is because of the existence of video. I can't tell you how important it is to catch incidents, especially excessive force, on video. I think there were two prior videos on this particular case, but if not, here it's not very long, but here is the video footage itself, filmed by my client as the police are at his front door, and he's worried, so he's starting to film.
Yo.
Come on. Trial out here.
I haven't done anything. I don't know what's going on.
Trial out here.
Huh?
Shut the fuck up. Trial out. Hands and knees. Come on.
I haven't done anything.
Is anybody else in here?
No, sir.
Okay, well, come on in.
I don't know what's going on.
You come.
What'd I do?
They're making him crawl to his front door.
Fucking listen.
I'm sorry, sir. I'm sorry. I didn't
Get the fuck out
mean.
of the goddamn house and get the fuck out of the house.
I'm sorry. I didn't
Anybody
understand.
else in here?
No, sir. I'm sorry. I don't know what I've done. Oh, my head. Oh, my head.
And then that's where the other officer comes up and appears to have turned off the video. Now he wasn't the one who used the excessive force, and I think the testimony would have been that he happened so quickly he wasn't in a position to stop the boot stomp. That may have been the case, but we also alleged that he stopped the video and also attempted to delete the video. We never got to the point to where we got to put them under oath and to ask them questions about that. So I don't know exactly what it is that they would have said, but who are you going to believe, me or my lying eyes? Because it's right there on video. And that's the great thing about video. There's a U.S. Supreme Court case, Scott versus Harris from 2012, that says even if law enforcement officers testify to something that's contradicted by video footage, the court is absolutely entitled to just use the video footage as a matter of law. So that this had happened all the way back in March 12th of 2019, and again, this was my client's house. The police were looking for just a guy who was visiting his house, and I believe they did have an arrest warrant for this other guy, but he didn't live there, and that did not entitle them to come into his my client's house. They could have gone into that guy's house or to any house he was living at, but it didn't entitle them to go into the house of a third party. So that was an important, I think, component of this case. And then, of course, you have the excessive force. The good thing about excessive force litigation is that if you allege the case properly, if you write the complaint properly, you're almost guaranteed to be able to get to a trial. It's very difficult for them to get qualified immunity for an excessive force complaint that is properly alleged. So that's pretty much it. Just a quick video to show that we're not just filing cases and talking about pending cases, but also resolving them. If it's through a trial, fine. If it's through a settlement where the other side steps up to the table, and I don't want to give the exact figure here, but this was a six-figure settlement. Um, and you saw that there was damage that was incurred by my client's head there. No medical bills or anything like that. So I think it was a good outcome here. My client it was is very 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 happy over the result, and it's always the client's decision whether or not they want to accept the settlement. And I think it was fair in this case. I think it was the right outcome. I think the government did the right thing here in the end. Discipline wise, somebody had asked me. I don't know. The primary officer, it's my understanding, that was involved in this is gone. The one that was also there and turned off the video, I have no idea whether there was any discipline there. And again, I don't have any control over that. This is just a civil case that we filed for the remedy that we have, which is to get money. Um, but if you want to be involved with the other potential remedies out there, you got to talk to the prosecutors and talk to the agencies themselves. So that's pretty much it for now. Have some other updates soon on other cases, hopefully soon. So appreciate you following along. Please subscribe, and I'll see you next time.